Okay, today is Tuesday, May 5th, 2026. It is 1:30. Welcome back to Harris Hall. First up, we have item 9A. This is a de novo hearing. Mr. Gilbride here. I'll open it up if you're ready.
Thank you. I think, could you read the title in the script?
I said I'll open it up if you're ready.
Oh, yeah, cool, yeah. I thought you were just passing it to me right away. I was gonna
Not yet.
jump in.
Okay. I will now open a de novo hearing for planning action file number 509 PA 2405491. Today's date is May 5th, 2026, and it is 1:30 p.m. The full agenda title for this item is as allows. In the matter of reviewing the hearing's official decision affirming the planning director's denial of 3 legal lot verifications for 3 properties identified as assessor's map and tax lots numbers 18021600000300, 00304, and 00305. Together as property 1, a portion of 180216000020, as property 2 and 18021600000301 as property 3 pursuant to Lane Code 13140 and 2 property line adjustments among the 3 properties pursuant to Lane Code 13130, file number 509 PA 2405491. Okay, this is a de novo hearing per Lane Code 14080-5C3 and Board Order 26040702, Lane Code 14080-5C3. And the definition of de novo under LC 14015-9 provide that new parties may participate in this matter, and any party may present new evidence and legal argument by written or oral testimony before the board. The purpose of this hearing is to hear arguments regarding the application that what was before the hearing's official for file number 509 PA 2405491, a hearing's official affirmation of the planning director's denial of 3 legal lot verifications and 2 property line adjustments. For those of you who are here in person or online, there will be an opportunity to challenge commissioners' disclosures and abilities to participate in this review of the hearing's officials' decisions. Failures to raise an issue accompanied by statements or evidence sufficient to enable a response may preclude appeal of this issue to LUBA. The order of the proceedings will be as follows. Staff will present the director's staff report. The applicant will be heard. Persons in favor of the proposal will be heard. Persons neither in favor or opposed will be heard, neutral parties. Persons opposed to the proposal will be heard. Staff will respond to testimony and evidence provided. The applicant will provide final rebuttal and the hearing will be concluded. After each presentation, the commissioners will have an opportunity to ask questions before moving to deliberations and decision. The board's decision will be the final local decision appealable to the Land Use Board of Appeals. Okay, so at this time, commissioners must disclose any ex parte communication. If any commissioner has received ex parte communication, please record it for the record. Commissioner Lovell.
None, Fee.
Commissioner Farr.
I have none.
Commissioner Trieger.
None.
Vice Chair.
None.
And I have none. Okay, now I will ask the commissioners to disclose any personal knowledge, bias, prejudgment, or conflicts of interest related to the matter before the board. Commissioner Lovell.
I have none.
Commissioner Farr.
I have none.
Commissioner Trieger.
None.
Vice Chair.
None.
And I have none. Now I will ask commissioners to state whether there are any abstentions due to any conflicts or bias stated. Commissioner Lovell.
I have none to disclose.
Commissioner Farr.
I have none.
Commissioner Trieger.
None.
Vice Chair.
None.
And I have none. The applicant and those in attendance are allowed at this point to challenge disclosures and to challenge the qualification of any commissioner based on bias, prejudgment, or conflict of interest. Challenges will be limited to 3 minutes, and please be sure to state your name and mailing address. Do we have any challenges to commissioner disclosure or qualifications? Okay, seeing none. To the staff report.
Okay, great. Thank you, Chair, and good afternoon, Commissioners. For the record, my name is Kevin Gilbride, Staff Planner, and this is the Lane County Staff Report or presentation to the Board of County Commissioners for Planning Action File Number 509-PA24-05491. First, I'll give a quick outline of the presentation. So I'll go over background info, a summary of the application, summary of the hearings official's decision, summary of the Land Use Board of Appeals case known as Doughty, comparison of the subject hearing official decision to Doughty, potential fixes available to the applicants in this case, then board action alternatives, and finally, we will have discussion and questions if there are any. So first, I wanted to start off by giving you a quick refresher on what a legal lot is. You might recall a lot of this from our work session last spring regarding the topic, but as a term, legal lot is used broadly as a concept for understanding how a property was created and whether its creation complied with planning, zoning, and subdivision or partition regulations at the time of its creation. Although specifically defined by Layton Code, the term is often used informally and broadly in county planning. When people refer to a property as a legal lot, it could mean that the property is a lawfully established unit of land that was verified and noticed by Lane County through a legal lot verification, or it could mean that the property was created through a county-approved land division process. As defined, a legal lot verification is a determination or decision made pursuant to Lane Code 13140 that a unit of land is a lawfully established unit of land. The purpose of a legal lot verification is to determine if and when additional development rights were established by virtue of the unit of land being lawfully established. In other words, legal lot verification is essentially a research project into the history of a property to figure out if every conveyance or reconfiguration that occurred after the institution of regulations in 1949 was lawful. In this case, the applicants proposed verification for 3 units of land. They're shown in the map here. Properties 2 and 3 were determined as legal lots. Property 1, the large light blue property encompassing tax lots 300, 304, and 305 was determined unlawful. Now I'll get more into that now. So in this case, subject property number 1 was lawfully established in 1960, and that's shown in figure 7 of the planning director's decision, and that's provided here on this slide. And shown as the yellow property, the large yellow property. This is the property proposed for verification by the applicant. Staff generally agrees with the applicant here that the configuration of properties, tax lots 300, 304, and 305 was lawfully created and could likely be verified as a legal lot if it remained in that configuration. However, subject property 1 was unlawfully divided on March 2nd, 1972, when the pink property shown here in figure 10 from the planning director's decision was created out of a larger yellow property, At the time of the land division, Lane County required partitioning approval prior to creating new properties. No approval was received for this division. The applicant's agent argues that for purposes of this application, this unlawful division can be ignored or treated as having no effect on the greater lawful unit of land. However, pursuant to the Land Use Board of Appeals decision in Doughty, although unlawful, the 1972 deed acted to divide the subject property into 3 units of land, identified as tax lots 300, the larger yellow property, in figure 10, 304, the pink property, and 305, the smaller yellow property. The property remains in this unlawful configuration and therefore cannot be verified as a lawful unit of land until the unlawful division is remedied. As of the time of the planning director and hearings officials' decisions, the unlawful division had not been remedied. So now I'm going to talk about Doty for a minute. In Doty, the Land Use Board of Appeals considered that Lane County's approval of a replacement dwelling in the exclusive farm use zone was unlawful because the property where the replacement dwelling was proposed was not a lawfully established unit of land. The sequence of events relevant in Doty is shown here. Much like the subject property number 1 under review today, the property in Doty had originated as lawful, and that's shown as the property labeled A, but had been divided unlawfully by deed in 1992 at a time when the land division regulations required that a property owner receive approval for a partition of this type of division. This is shown as properties B and C. No approval was received for that division. So according to Luba in Doty, in the context of land use law, the lawful status of the subject property could only have been preserved if the county had approved the 1992 conveyance dividing the property into 2 units of land. Because no approval occurred, and because the controlling statute for replacement dwellings requires a lawfully established unit of land as a criterion, Luba found that the county's decision was prohibited. We couldn't have approved it because it wasn't a lawful parcel. For their decision in CSC Holdings, this subject application, the hearings official reviewed the Land Use Board of Appeals decision in Doty and the local decisions leading up to the Luba decision and concluded that Doty supports the planning director's denial. Based on Luba's position related to the effect of an unlawful division on the legal status of the resulting properties, the hearings official agreed that the planning director could not make the code required finding that subject property 1 was a lawfully established unit of land, and therefore the director properly denied the subject application. The hearings official also directly disagreed with the appellants in this case that Doty and its discussion of the defining statute for legal lots supported their position that property 1 is a legal lot. The hearings official explained that the county and the local decisions that led up to Doty and the decision in Doty itself had effectively made the same argument that the appellants in this application are making, that an unlawful conveyance via a deed where the property owners did not obtain land division approval does not create illegal parcels. The lawful parcel remains a discrete lawful parcel, albeit with 2 owners with divided interests in title. This argument depends on the idea that an unlawful conveyance, because it was unlawful, does not serve to divide the property for land use purposes. But both Luba and the hearings official have directly disagreed with this argument, which, as I've said, is the exact same argument presented by the appellant in this case. And the hearings official therefore affirmed the director's denial. Now, after all this discussion of minutia for this one, you may find yourself wondering what property owners can do to fix unlawful divisions like this. And since the Doty decision, county staff has been looking for a no further harm win-win option for property owners to fix situations like this. And we've come up with or have seen used a few options for property owners, and those are shown on this slide. The first is a property line adjustment deed to vacate the unlawfully created property lines. This action works by essentially deleting the existing property lines and bringing the property back into its lawful configuration. The second is a warranty deed where both property owners become owners of the proposed legal lot. This action works by creating a single unit of land, just with divided interest, restoring the lawful unit. And the third is a rescission deed that explicitly goes back and rescinds or undoes or deletes the 1972 instrument that divided the lawful property. This action works by undoing the division at its source and restoring the lawful unit of land. And I want to stress a couple of things regarding these options. Since the very beginning with this application almost 2 years ago, the county has notified the applicant and their agents throughout this process that subject property number 1 would not be approvable in its current configuration. We suggested they employ one of the potential fixing options shown on this slide on multiple occasions, and they refused. If the applicant had employed one of these potential fixes, this process would likely have been completed over a year ago. Instead, we are here before this esteemed body where the applicant is seeking for the board to reinterpret decided case law from a higher court. Instead of recording a approximately $200 instrument with deeds and records. Not only is this improper because a simple, much cheaper and less time-consuming alternative existed for the applicant, but also because there is no room for the board to interpret the decision from LUBA. So finally, in this case, county staff, along with county council, believe the hearings official's decision is sound, that it correctly applies Lane Code Chapter 13 and controlling case law, including Doty. Additionally, the key issue of the effect of unlawful land divisions on a previously lawful unit of land is already settled law and is not an interpretation of county policy. The issue has been decided by the Oregon Land Use Board of Appeals in Doty, and the Lane County Board of Commissioners does not have discretion to reinterpret or overturn LUBA's interpretation of state law. Although the issue in this case occurs throughout the county, the director does not consider that the board has room to further interpret it. As such, we recommend option 1, to ratify and affirm the hearings official's decision and to remain silent on any further interpretation. But if the board wishes, we can explore alternative options through discussion. So in closing, I'd like to thank the board for their attention, and I'm available for questions. Thank you.
Okay, thank you, Mr. Gilbride. To the board, any questions? Commissioner Trigger.
Thank you. Pardon me. Thank you for the presentation. Are the potential fixes, do those exist even after and if we uphold the hearing's official decision? Are those in place, or what's the order of operations for the appellant availing themselves of those remedies?
Could they exercise them, is your question? Yeah, the decision, so if you uphold the hearings official's decision and it doesn't go to another level of court, then the applicant could fix their, the issue with property 1 and reapply and likely receive approval. I can't make that land use decision here, but.
So ultimately, they can get approval for what they're seeking if they use one of those remedies, most likely.
Yeah.
Thank you.
And, sorry, we have seen it conditioned in decisions before as well. It's not the cleanest way to do it, but the hearings official has given conditions for property owners to exercise one of these options, like a property line adjustment deed, to fix a problem that happened in the past. And then once that's submitted, then the decision was considered final.
Thank you.
So that happened once. And it went to LUBA and then was dismissed. So just for background information.
Commissioner Book.
Thank you. So if we have some potential fixes that seem to not cost a lot or take a lot of time, and we've already got precedent from a higher jurisdictional level, I'm curious why we're here. Why come to this board at this point and wait the additional time? And maybe that'll be addressed in the appellant's argument, but that makes me very curious.
I don't exactly understand it fully either, other than that I know Mike Reeder's going to have some things to say about it, but the only reason that I can even think of that we would be here instead of recording one of the $200 instruments is that they haven't been fully tested. They haven't been fully vetted, and there's no law at the state level that says how to fix problems like this. So we've seen people use these instruments that we show on this slide, the property line adjustment deed, a warranty deed, or a rescission deed to fix problems that have happened in the past. And we've been okay with them locally, and the hearings official in some decisions has ruled on them locally, but they haven't been specifically reviewed and tested by the Land Use Board of Appeals or a higher court. So I think people are afraid of that happening. But I don't know if it will happen. I can't predict if somebody's going to take it to LUBA or not.
Commissioner Farr.
Thank you, and thanks for the presentation. Just making sure I'm understanding what it is that you're saying. Providing findings that negates any of the options that are asked for by the appellant. Is that just a simple yes, no on that?
Can you,
Your findings here, it says move to adopt the attached order, ratify and affirm the county hearing official's decision. But earlier in the document, you say that the findings that have been provided, that have been determined by the staff, rule out the appellant's legal options.
yeah, well, our findings address how the hearings official's decision states that the argument presented by the appellant is not correct, that their interpretation of Doty is not correct.
Your findings are based upon the hearings official's determination. Then you've offered 3 potential fixes, all of which you state, Mr. Gilbride, that they're inexpensive and faster.
Yeah,
Did I hear you say that?
yeah, they would have been, yes.
Would have been, but you have some question in your mind right now as to whether or not they're available.
They're available after this process unless we come up with a way to condition one of them.
Okay. Then you also stated that the reason that these potential fixes have not been exercised in the past is because there's some question as to whether or not it would be referred to LUBA and how LUBA would respond,
I think some people are afraid of that.
which is probably a legitimate fear in some people's minds, I would suspect. That's speculation on my part. But so these 3 potential fixes may take a long time and may end up being expensive. And that's what I've heard you say anyway. My last question on that is that you stated that state law is unclear, which gives a great deal of latitude to local law. Is that am I correct in that presumption?
I don't,
Latitude to a deference to local decision making.
in state law regarding legal lots, like lawfully established units of land, I don't think that's unclear. And how that law, because lawfully established units of land are essentially regulated by a definition in state law. It's ORS 92017, and it defines what is a legal lot or a lawfully established unit of land. And I don't think there's any lack of clarity with what that means.
Then maybe, that wasn't my question.
Okay.
You stated state law is unclear. What were you referring to?
I don't remember saying that.
Can the recorder play back the minutes? No, but
Yeah, I need a
it's not a court,
stenographer.
is it? But, you did. You said state law is unclear on it. And I'm
Was I
trying to grasp where the
referring,
state law is unclear and where local deference supersedes what may be a very vague state law.
I guess I'm not sure where I said that, I'm sorry.
Could you go back on your notes? Because
Yeah.
I was listening rather than typing.
Yeah, I don't,
No, just clarifying where I think that he was mentioning the lack of clarity at the state level is with regard to those 3 possible fixes, not the answer to the question that this case
Do you
presents.
concur
That's it,
with
yeah.
that?
Is that right?
Okay, well, that still is the same. So the lack of clarity there in state law, does local decision-making have deference then? in that.
Yeah,
in that
and
case.
that's what I'm saying regarding people not having 100% faith in these three options that they can use or exercise to fix legal lot problems, because state law doesn't actually list them as options to fix it.
Doesn't list them as options.
And so we haven't had them specifically tested at a higher court to say that, yeah, this one works and this one doesn't.
So that could be, that's why we have one attorney over
no,
here who says it will and one attorney over
Yes.
here who says it won't. There's
I
a
do-
difference there.
I do agree that there
And
is
that's why it's here,
some
is
level
because we're
of
the
deference
decision maker on the
in that
difference.
sense,
Okay,
yeah.
thank you.
When, like, if you wanted to exercise one of these options through this decision and have it be, and then maybe it gets taken to LUBA and LUBA analyzes it and says yeah or no,
Mm-hmm.
they might rely on your, or give more deference to your decision.
So the potential fixes then are vague. I mean, they may be fixes, may not be fixes, depending on how long it takes, how much it costs, and whoever's willing to take it as far as it may need to go. So the potential fixes that we have proposed aren't given potential fixes. Okay. I may have more questions, and I'm not trying to nail you on anything there. I'm just trying to make
No.
sure that I understand
Yeah.
where the vagueness is and where the decision-making at this Board of County Commissioners lie and where we don't have decision-making authority. But it seems to me as I've not heard of any point where we don't have decision-making authority on this, so.
It's not in regards to the fixes. These are all, to be 100% clear with you, the three fixes are ones that the county thinks are potential options for people.
Sure.
And I do think there is deference for you to interpret those. But when it comes to the decision in Doty and how it applies to this application itself, I don't think there's deference for the board there. So you could come up with an option for them to fix their problem, but I don't think there's an option for them there's not an option for you all to interpret Doty.
Because that's been interpreted already.
Yes.
Absolutely. I would not expect that we'd be able to interpret past decision-making by courts. So, okay, good. That's my questions for now. I may have more questions as we proceed. Thank you.
Commissioner Lovell.
Thank you, Chair. My motion to you was like this. I was thinking that I got a lot to grind in my head before I make a comment, but I think as we're going along here, these three decisions really look like two in my mind, because you have a property line adjustment to the previous configuration, moving back to what it was in the yellow, or the number three is the rescission of the unlawful division, which basically puts it back to what is in the yellow. So really, in my mind, we have two decisions, and my curiosity is to put the lot back in its original configuration, and then fix two is if you have two buyers that agree to occupy one legal lot with a line down the middle of it, how does the county then issue a building permit on one side or the other?
Well, if they did a warranty.
If it doesn't meet a template dwelling or such other
Yeah.
criteria.
If they were trying for a warranty deed to fix this problem, our option that we presented to them back in, was, I think we did it first, June 5th, 2025, and then second, June 20th, 2025, was for them to record a deed that puts everything under one ownership, but then provides an addendum to it that describes the actual legal description of each portion that's owned by each party, so that it's exactly known who owns what, and then that retains each party's ownership. So there's no question of, it's like, I'm trying to clarify that there's no line down the center or anything like that. It would look similar to this with the two yellow properties and the pink property, but it becomes that single larger yellow property
right.
again. But the chambers, the Kelly Chambers and the trust own that pink property or portion of that property, and then CSC Holdings owns the two yellow portions, but they're all one property.
I'm totally on your page, Mr. Gilbright, but my question is this, is that typically when you divide something up, certain people have certain percentages of ownership. So ultimately, if I have a 100-acre property, I divide 46 acres, that means technically they have 46% of the interest, I have 54% of the interest. Who makes the final decisions on whatever happens to that property? Is that an equally split from the two owners? They have equal 50-50? Or does it become a percentage on who's parlayed off what? I mean, that's where, to me, this gets really sloppy.
Well, Yeah, I can see that being a problem, and but what I'm thinking is that if you exercise this option, then you're also exercising the option to do a property line adjustment. And when they do the property line adjustment, they're moving the property into the configuration of who actually owns of each part. And the property lines are then, once the property line adjustment is recorded, they're in the configuration of ownership. So that problem of 50% versus, or 54% versus 46% is null.
They become autonomous to their own properties.
Yeah, because they've adjusted the lines through, they've recorded you record your warranty deed, you record your property line adjustment deeds, and then your problem's fixed.
Okay, thank you.
Yeah, I'm kind of going to circle back to something that was said earlier. I mean, because option number 3 is move to adopt the attached order and direct staff to return with the revised order, reversing the hearings official's denial and conditionally approve the application with findings of fact that include the board's interpretation of Wayne Code 13 and associated case law. So if that's an option, that's saying that with our interpretation of Chapter 13, you could come up with findings that would support these lot line verifications, lot line adjustments?
You mean if you wanted to reinterpret whether the properties were lawfully established, whether we could make findings as to whether the property line adjustment was lawful?
Well, I'm back to trying to get to why we're here. I mean, that's option 3. That is one of our options. And that includes the board's interpretation of Wayne Code Chapter 13 and associated case law. So what would that interpretation be?
That option is there for you to exercise your ability to reinterpret the existing case law if you so wish. That's the end of my thought.
Good afternoon, Chair, Commissioners. I just wanted to encourage, before we get maybe too deep into this discussion, is to hear what the applicant has to say. They might make some, they'll make arguments on their side, and then we'll have another chance for discussion and in our rebuttal to their comments, and that might give staff a better understanding of what those findings could look like, just as a suggestion.
Yeah, I can see that. Did you want to say something, Vice Chair?
I'll wait till I hear from everybody.
Okay. Commissioner Farr.
Thank you, and thank you, Ms. Ackner, for that. That's what I was trying to get to, was to hear from the appellant, because if somebody asked me to write findings, boy, I'm going to fail. I'm not going to write findings. I'm not going to do it. I count on somebody doing that for me, somebody who can interpret and knows how to write it. So when it comes time to, if we do exercise option 3, and option 3 says the board's interpretation, there's nobody up here can do that. We need help doing that when that step comes, should that happen to come. So just get that on the record that I don't write code. I don't write responses to legal challenges. That's what I hope staff will help us to do when the time comes. So, should the time come. Thank you. And thank you for that clarification, because we've got a lot to hear before any further discussion has to happen. And thank you, because Mr. Kilbride, every dealing I've had with you, you and I have kind of the same thing in mind. We want to clarify it, make it easier for people to build, easier for people to build legally, and easier to avoid challenges to what we're doing moving forward. I think we have the same goal in mind. So look forward to that. Thank you.
Okay, next up, the applicant or applicant's representatives may provide their presentation to the board. Please be sure to state your name and address for the record. And we have time for Mr. Reeder and Mr. Farrington, if I said that correct?
Yeah, Phil Farrington. For the record, Chair and Board, my name is Mike Reeder. I'm at 375 West 4th Avenue, Suite 205 in Eugene. I represent the co-applicant CSC Holdings, and here with me today is Silva Chambers of CSC Holdings. I'd like her to speak briefly about less than 30 seconds before she has to leave. And then the other co-applicant is Kelly Chambers. She has about a 30-second statement that she would like to provide. After those two statements, I will provide the legal analysis. And after I'm done, Mr. Farrington will conclude the applicant's case in chief. So I'll turn the time over to Silva Chambers first, and then Kelly Chambers.
Good afternoon. My name is Silva Chambers, and I represent CSC Holdings. The address is 800 Willamette Street, Suite 750, Eugene, Oregon. And I'd like to point out that the property has been in my family for over 60 years. It was my parents who separated or partitioned the property. At the time, it was an operating cattle ranch, and they had built a residence, and it's my assumption that they pulled the residence out of the operating company. I am Kelly Chambers, who's going to speak in a moment. I am her sister-in-law, and it's important to me that she be able to pass this property on to our heirs, her children, and have the ability to do what they need to do with the property someday. We've spent an exorbitant amount of time and money on this issue, and we just hope the Board of Commissioners will do the right thing to help us and countless other landowners caught in this similar situation that are unable to fight for their rights of their property. Thank you.
Good afternoon, Commissioners. I'm Kelly Chambers, and my mailing address is P.O. Box 640, Pleasant Hill, Oregon, 97455. So you heard from Silva that the home that I am living in is been a residence since over 57 years ago. I have been in that house 27 years, and it is concerning to learn that the county is now interpreting the code to say this is an illegal lot. Yet it's legal enough that I've been paying taxes on the property. My concern is not only for the estate planning that I have for my surviving daughters and the need for them to address this misinterpretation so they don't inherit the confusion, but also going to the time and expense that we have as a family to try to resolve this so that it could be a peaceful resolution. We hope that it can help correct the record for others who find themselves also in similar situations. Thank you.
Again, for the record, Mike Reeder. Thank you, Kelly, and thank you, Silva. I wanted to give them the opportunity to testify before they had to leave. Again, representing CSC Holdings, why are we here? Okay, we've heard that question before. Well, for one reason, the reason we're here is because the Lane County Code, Chapter 14, provides that the planning director, in her discretion, can ask the board to review the hearing's official decision. So it's a code provision that allows the board, in its authority as the elected officials, the last stop before going to the state, to make a determination. So the question has been asked and raised by Mr. Malone, why is the board doing this? There's no deference given to the board's decision at LUBA or the Court of Appeals. And in a sense, that's correct. Saporin versus City of Medford, Oregon Supreme Court case, gives local governing bodies, such as the Board of Commissioners, Saporin deference when they interpret their own code. Now, what we're talking about today is state law that has been implemented by the code. So why are we here? We're here to correct the hearing's officials' decision before we go to LUBA and the Court of Appeals. I want to correct something that Mr. Gilbride said when he talked about the Doty decision, which I'm going to speak about in a little bit. Doty was decided by LUBA, the State Land Use Board of Appeals, which is an administrative board. It is not a court. I believe you mentioned it was a court, and that's an important distinction to make. The Court of Appeals reviews LUBA's decision and reviews LUBA's decisions frequently. So why are we here? Well, we want to make sure that should this case go further to the State Land Use Board of Appeals and to the Court of Appeals, that the record be especially clear. And my client and Kelly Chambers have been especially patient waiting for this board to hear and review the decision by the hearings official. Now, you in your capacity as the Board of Commissioners frequently and other boards throughout the state act in a quasi-judicial capacity frequently. This is your opportunity to put on your quasi-judicial hat and to review the decision of the hearings official, because the hearings official in this case got it wrong. He got it wrong in a way that is very impactful, not just to my client and not just to Ms. Kelly Chambers, but also to a wide variety of property owners in Lane County. When this issue came across my desk, with this client and with Kelly Chambers, I soon had 3 other clients who do not have the ability to spend the time and the money to come before the board or to LUBA or the Court of Appeals to advance this very important issue. So the chambers have been very magnanimous, and basically they are the test case for Lane County. Why are we here? I don't know of any other county in the state that has taken the position that staff has taken here by interpreting Doty to say that when a property owner who has a lawfully established unit of land, so in this case, Mr. Gilbride, would you turn the slide back to one of the maps that shows the 1960 configuration, the yellow? You can leave it there. So if you look at the property in yellow and then also the pink, imagine that pink being yellow. In 1960, that property that's all in yellow and pink was conveyed in 1960 before there were any subdivision or other land division ordinances. So back before there were land division ordinances, a person could convey property, and when that person conveyed property, they also divided it. So in 1960, when the yellow was created, actually, Mr. Gilbride, would you go back one slide, please? Yeah, so right there, you see there's at this point, if you look at the yellow, those are the 3 tax lots in question. We are asking that this board review the hearings official's decision to determine that that property in that configuration is a legal lot. And then if you'd advance the next slide, please, Kevin. In 1972, a predecessor in interest conveyed the pink property that is now owned by Kelly Chambers. That conveyance was done in 1972 when Lane County had land division ordinances that applied to this county, and they did not go through the proper land division process and get county approval. That was an unlawful conveyance. In other words, that conveyance may have and did convey legal title, so the pink went, the legal title transferred, but it did not divide the property pursuant to law. Okay, and that's a very important distinction, and that's the issue today before you. And I'm happy to answer questions if you have questions at the top of your head right now before I move on.
Can you just repeat that last sentence you said?
Let's see if I can try. I'll try. If you can ask Kevin to do it, it's fair enough for me to try and, the conveyance in the conveyance in 1972 was a conveyance pursuant to ORS 93, but not a lawful conveyance pursuant to ORS Chapter 92. In other words, legal title transferred to the grantee in 1972, but the boundaries of the legal lot in yellow did not change. So those, the pink there, the boundaries of between the pink and the yellow, those are not boundaries for land division. So it's often real estate agents in Lane County will talk about, they'll advertise tax lots for sale. And as a land use attorney, that always makes me cringe because as you know, a tax lot doesn't necessarily mean a legal lot. And so that pink became a tax lot, but it did not become a legal lot. state law, state statute that was adopted in 1985 and codified in ORS 92-017 is what's at issue today. That states that a lawfully created lot or parcel, and in this case, it's, if you turn back, please, Mr. Gilbride, all of the yellow. No one argues that the yellow is not a legal lot. It was lawfully established back in 1960. A lawfully created lot or parcel remains a discrete lot or parcel unless the lot or parcel lines are vacated. So there's a vacation process similar to land division, or the lot or parcel is further divided, and here's the critical piece in the statute, as provided by law. So when, in 1972, when the Pink property was conveyed, that was an unlawful conveyance because it did not receive land division approval from Lane County. The Doty decision does not, we believe that county staff and the hearings official are misinterpreting the Doty decision. And I've provided you briefing about why that is the case. And the Doty decision is, I think it's easier and probably will save us time if I simply go to the Doty decision, because that is the crux of the misinterpretation by the hearings official. So in Land Watch Lane County versus Lane County, Doty, that was decided October 2019, the Land Use Board of Appeals reviewed the hearings official and the Board of Commissioners' decision to approve a replacement dwelling on a property that was similar to the Pink property. In other words, the property was conveyed unlawfully. It did not go through the land division process. And so what the hearings official said was the north part of the property, the remainder, perhaps you could go to the Doty diagram that you provided. Thank you. So let's suppose that the parcel C is the parcel that was, the land that was conveyed without land division approval. So it was a conveyance. It did not divide the land pursuant to law. It conveyed property to another owner. B and C together remained a lawfully established unit of land. What Doty says is, yes, C is, and Luba uses the term an illegal lot, and really it should say it's just not a lawfully established unit of land by itself. But the hearings official incorrectly determined that B was, as a remainder, was a lawfully established unit of land. And Luba said that that's incorrect. And I agree with Luba's holding, that Luba got it right in that respect. We're not asking this board to step over Doty. What I am saying is that staff and the hearings official are misapplying Doty. And I've provided you extensive briefing findings, if you will, that will demonstrate that that interpretation of Doty is a misinterpretation of Doty. And the Killian case and the Castle majority decision makes that very clear. So the Doty decision, here's the important part of the Doty decision. It says here in 1992, the 1992 deed, so very similar to our 1972 deed, there was a 1992 deed, conveyed a portion of the larger property into different ownerships. However, new parcels were not lawfully created because that conveyance occurred after land use laws regulating land division became applicable. And then Luba cites the statute that you're looking at today, which is ORS 92-017, which provides a lot or parcel lawfully created shall remain a discrete lot or parcel unless the lot or parcel lines are vacated or the lot or parcel is further divided as provided by law. And Luba emphasized the as provided by law. This is I think this is where staff and the hearings official got tripped up. It's the next provision. It says, In the context of land use law, division by law, again emphasized by LUBA, requires a subdivision, a partition, or prior to the applicability of land division regulations, a deed conveyance. We conclude that tax lot 1400, so in our case, it's the pink piece of property, but in Doty, it was tax lot 1400, standing alone is an unlawfully created parcel, and a replacement dwelling may not be authorized on tax lot 1400. That's the holding of Doty. Doty does not stand for the proposition that when there is an unlawful conveyance, that there is a division of law that's unlawful and you now have two unlawful or two illegal lots. That's not what Doty said. That's certainly not what Castle says, because the Castle dissent, actually the dissenting opinion, dissents are very rare at LUBA, but there was a dissenting opinion that basically made the argument that is being advanced by Land Watch, by county staff, and then adopted by the hearings official, which we are asking you to correct so that we don't have to go up to LUBA and make that case there. We may have to, but that's okay. We want to get the record correct here. I'm going to pause for just a second because I've thrown quite a bit at you and want to see if you have any questions before I finish my case in chief.
Any questions for Reader? Mr. Farr?
Thanks. I'm looking at this diagram right here, A, B, and C. In this diagram, neither B nor C are lawful lots,
Standing alone, they are not lawful.
but A remains. So B and C together remain inside of A, which is a lawful lot.
Correct. In our case here, the 1960 conveyance that was lawful because it was conveyed, it conveyed property and it divided property. That happened without land division laws being applicable, so therefore it was conveyance and a land division. And ORS 92017 says that when you have a lawfully established lawfully established unit of land, lot or parcel, it remains a discrete lot or parcel unless vacated or further divided as provided by law. Now, Mr. Basham in the Castle dissent, the board member talks about this being a metaphysical question, and he struggled with it because I think he felt that it was some type of loophole. It's not a loophole. It's just simply someone went through this process of conveying property without going through the land division ordinance. We're not trying to do anything that would further allow additional development. So to give you some factual background, my clients actually, they farm the property. They grow pumpkins, corn, broccoli, and other things. Ms. Chambers, as she testified, she's lived in that house for a couple of decades. It's been a lawfully established dwelling for over 50 years. So what we're trying to do is unring the bell that happened in 1972. Now, since it was raised, and you had questions about this, the potential fixes, like why are we here? Why are we wasting all this time? Well, I'll tell you, some of my clients don't have the cooperation of their neighbors. I have a client right now who is in a very similar situation, and he doesn't have the ability to go to LUBA and the Court of Appeals and fix this. But he's suffering from the same defect where he has property that was unlawfully divided years ago, and he wants to do a lot line or a property line adjustment, but he cannot because in order to do a property line adjustment, you have to have a lawfully established unit of land.
And he doesn't have the wherewithal to pursue it.
He doesn't have the wherewithal to pursue it, but more importantly, his neighbor is uncooperative. He and his neighbor together own divided interests of a legal lot. My client would like to correct it. He cannot get his neighbor to cooperate with him. And so he doesn't have that ability. There's another potential fix for some people. It's called the validation of a unit of land, and that's ORS 92, 176, and 177. That particular remedial fix helps a lot of people. I have clients who take advantage of the VUL statute, and it's worked well. It does not work in this particular case because in 1972, in order to get a validation of a unit of land, you have to have been able to do it in 1972. The law at the time required street frontage, and there's no street frontage there, so we would not be able to go in the Wayback Machine and take advantage of the VUL statute. It's Land Watch has suggested that that is the exclusive remedy. It's not. We are taking advantage of today's laws.
And if I may just summarize just to make sure I do understand it, I'm moving away from the Doty, and I'm moving to tax lots 304, 300, 304, and 305. In that diagram, 304 is pink.
Yes.
Same situation. 304 is a different tax lot. Thereby, Ms. Chambers is paying taxes on that. But it's not a legal lot because the only legal lot in this is what's labeled as 16, I think, which is a combination of 304, 300, and 305.
Correct.
Clear. Thank you.
Okay. Any more questions for Mr. Reader? Commissioner Buck, Vice Chair.
Thank you. I'm still kind of back to the original question that I asked, which is if one of the options here costs $200 to fix, why wasn't that pursued? And why spend all the additional time and expense?
Great question, Vice Chair. Let me ask Mr. Gilbride, could you pull up those 3 potential fixes? Thanks. Okay, let's talk about the potential fixes. The first one, property line adjustment deed to vacate unlawfully created property lines. It's our position that the lot lines were not created when the property was conveyed. In order to do property line adjustments, you have to have, the first step is that you have lawfully established units of land between all properties. So I'm not saying it couldn't work, but in the cases that I'm talking about, my other clients, they have to you have to have cooperation from the neighboring property owner. And in many cases, they don't.
But in this case, they do.
Well, in order, so to vacate unlawfully created lines, you have to, again, like I said, it's circular. You have to have a lawfully established unit of land. This is what we're doing. We are simply asking that you recognize the 1960 lot as a lawfully established unit of land and do property line adjustments between 2 other lawfully established units of land. I see no point in going through the process. I would be happy to hear the explanation, but I have heard that there are people who are going to challenge that particular approach. The other 2, a warranty deed, you are essentially asking unrelated entities to merge their holdings. In many cases in Lane County, people have mortgages. That's going to be very cumbersome, very difficult. And then the rescission deed, again, rescinding that deed, you're basically putting all the property back in one ownership. What we are, to answer your question simply, what we are trying to avoid is having to put the property back into one unitary ownership. That may occur, that may be a remedy for some folks, but it's not a remedy in this particular case and not a remedy for many of my other clients.
Okay, I think I'm understanding where your position is. So way back in the day, these different lots were conveyed to different heirs of the land. And decades go by and nobody thinks any different all this time. Now comes a time where, you know, they want to act on their property, maybe do some succession planning for that property. And so now you're interested in ensuring that each of those 3 are legal lots in order to do the separation. That's ultimately what I think that you're trying to accomplish here. Am I right?
Correct.
Okay. And from the hearings officer's position, they're saying you cannot do that because the original conveyance was not legal.
Correct.
Okay. And what you're telling me now is for these 3 options in front of us, none of these three options are actually going to fix the problem that you're trying to solve at the moment, for various reasons.
Yes, practically speaking, that's correct. I wouldn't foreclose that we could use one of those avenues should we be unsuccessful here, but it's not, we don't believe it's the appropriate avenue, and we don't think it's the, my client doesn't believe that it's the, it didn't make sense at the time, so, yeah. But I'm not going to say it's never a possibility, but I think the concerns that were raised about somebody else challenging one or all of those possibilities, I think it's a real possibility, yeah.
I see. So you're concerned if you pursue one of these three, you'll have people that are be opposed to pursuing them, which may challenge it, and it's not as simple as paying $200 and adjusting something.
That's correct.
That's your argument?
That's correct,
Okay.
Vice Chair.
Okay, thank you. That clarifies, and I'll have follow-up questions for staff.
Yeah. I would also pull back for just a second. I think it's an interesting question, and I appreciate staff looking for avenues of, getting to yes. That's always appreciated, but we simply disagree that that's the right approach in this case. And it's like, we have the right to go this route, we're going this route. It really isn't relevant to the issue before you today. So I think it's like, you have a First Amendment right to speak, you also have a First Amendment right to write, and to publish something. Well, we have a right to use the laws that are in place today, which is what we're doing. We're saying verify those 3 tax lots as a legal lot pursuant to today's standards, and then to do property line adjustments between lawfully established units of land so that Kelly Chambers can have her ownership being reflected in a legal lot. And that's why we're here.
Yeah, makes sense. Thank you. Commissioner Trigger.
Thank you. I'm honing in on understanding. So I have one sort of question and then a process question as well, and a little bit of a concern. The reason this matters is because ultimately, eventually, it will speak to how or whether there can be dwelling replacement. It's really less about where are the property lines than what can I do within those. That's right. It's a bit of a order of operations situation here, is you want this to get clarified so that?
Commissioner Traeger, I think you're correct in that there's probably two, you could break the motivation into two, right? There's a lawfully established unit of land, a lawfully established dwelling, and if something were to happen to it, you want to be able to replace it and have replacement rights, and in order to do that, you need a lawfully established unit of land. The second is Kelly Chambers owns the 15 acres, and they want to keep it in that configuration. They could change the configuration, I suppose, but that's not the intent of the applicants. So that's kind of a two-part answer to your question.
Okay, hold that thought for a minute. My other concern before I ask my process question of staff, as far as what our options are, is several times, Mr. Reader, you've mentioned, like you said, the hearings official got it wrong in a way that impacts several other clients, that the chambers are a test case for Lane County, but it's my understanding we should be looking at this one application before us.
Yes. Yeah, Commissioner Traeger, you're right. I'm asking you to look at the facts of the case and the law in the case in this particular situation. But similar to the questions about potential fixes, I wanted to make it clear, and there were questions asked, why? Why are we here? Well, I'm giving you the practical answer for why we're here.
I understand that. I'm just pointing out that you've also mentioned numerous times that what we may be doing is establishing something that impacts many, many other applications, and really we should be sticking to the facts of this specific application that the hearings official has made a ruling on, and now we're being asked to either uphold that ruling or, and this goes to my question for staff process-wise, if we're not going to, it's not up to us to say we don't want to, so staff find findings. We have to be able to articulate what those findings are. Staff will then put it into the proper language so that it's legal. Mm-hmm. But anyone on this dais that wants to deny the hearings official's decision needs to be able to state their case specifically for why and on what condition. We don't have to wordsmith it, that's your job. But it's not staff's job to figure out what those findings might be. Somebody up here has to be able to articulate what those are. Is that correct?
Yeah, I'm not supposed to talk right now, but yes.
Okay, sorry. Okay. It is my understanding that is correct, and when the time comes, if it needs to be corrected, I'm sure staff will do that. But I just want to make that clear because I may have been misinterpreting what I was hearing, was sort of like that there were some commissioners that may be thinking, well, if I don't want to support the hearing's official decision, we'll just direct staff to make findings, and that's not how it works. We have to be able to articulate why we're not upholding that hearing's official's decision. That's all I have for now. Thank you, Chair.
Okay. Is Mr. Farrington up?
Thank you.
Thank you.
Good afternoon. Thank you very much for allowing me to speak. My name is Phil Farrington. I've been working on behalf of the property owners to facilitate the land use applications submitted nearly 2 years ago to county staff. Thank you very much, Board Chair Senega, Vice Chair Buck, and Commissioners for accepting the Planning Director's recommendation to reconsider denials of land use applications that were submitted to address this issue that goes back almost, more than a half a century. In taking up this case, Commissioner Farr, you made reference to county experts, county staff that are experts in the agreeing to review the case. We've relied upon our own experts, not only Mr. Reeder, but a former county principal planner with more than 30 years of experience who's directed us and helped us guide us through this process. Mr. Tom Lanphier, really the fourth maybe option before us is the one that we applied for, which was simply to go through this process of using the existing process available to us through the county, but we're told by county staff, current county staff, that simply having both of the amenable property owners co-apply for these applications would not suffice. We disagree, and we think that there's precedence and there's establishment both in case law and in your precedent to be able to do that. As Mr. Reeder said, state law stipulates that lawfully created unit of land remains lawfully established unit of land unless vacated or further divided as provided by law. As was shown here, the originally assembled property in question was created as a lawfully established unit of land prior to land use laws and county's land division ordinances. The conveyance then by deed of a portion of that property without going through the county's partitioning process, we do not believe then creates two separate illegal parcels. It did not create a new unit of land. It did not result in destruction of the original lawful unit of land into two illegal or unlawful units of land. State law, LUBA court cases support our proposition, and we've talked about that. There may be two ownerships of property on separate tax lots, but for land use purposes, the conveyance by deed does not constitute a land division. It simply means that there's more than one owner of a single unit of land as tenants in common. This proposition was also supported and has been talked about in the submittals that Mr. Reeder has put into the county 2019 case that before the then county hearings official, Gary Darnielle, which the Board of Commissioners subsequently affirmed. Very similar to this case, it should have provided established precedents for future county decisions that conveyances of property by deed do not divide property, just as ORS 92.017 states. The separate owners of the property in question each signed county land use application forms to address this conveyance by deed. We do not believe that reassembling all of the properties into a single ownership is required or warranted, and the applications can and should be approved by staff as we originally submitted them. That is the fix, I believe, before you now, the fourth one that's not referenced up here. We ask you to concur with us, uphold your earlier ruling, state law and case law that believe does correspond with our premise for the applications before you now, and addresses this old problem with the county's current land use process. Thank you very much.
Okay, thank you. All right, so now we are to persons in favor of the application. Parties in favor of the application may provide presentation to the board. Please be sure to state your name and mailing address for the record. you, Rio. First up, Zach, something?
Mitke.
Ipke, all right.
Afternoon. For the record, my name is Zach Mitke. I'm an attorney with the law firm of Hutchinson Cox in Eugene. My physical address for my office is 940 Willamette Street, Suite 400. I'm here in support of the appeal by CSC Holdings LLC because the county is relying on the opinion in CSC Holdings to deny other legal lot verifications, including several verification applications that our firm has filed for our client, Fletcher Forestry Company. While I don't intend to argue the merits of the Fletcher case, this is not the venue for that. It is important for the board to know that the error in CSC Holdings has far-reaching impacts that go beyond this particular case. It is important to get this right. The crux of this matter, as Mike alluded to a minute ago, is whether an unlawful land division divides a legal lot. There is no dispute that property one, that is the large yellow property that we were talking about a little while ago, is a legal lot. It was lawfully created in 1960 at a time when it was unzoned and when the county didn't regulate partitions. And under Lane Code Section 13.140, subsection 3, any lawfully established unit of land will be approved for verification. That's the sole criteria for verification. Hence, the only way that Lane County could deny verification is if there is something else that destroyed the lawfully established unit of land or caused it to cease to exist. County staff indicates that property one ceased to exist when it was unlawfully divided by conveyance in 1972. However, with respect, an unlawful conveyance of property doesn't divide a lawfully established property. We know this because the legislature has enacted ORS 92.017. ORS 92.017 provides that a lawfully created lot or parcel that includes property number one remains a discrete lot or parcel unless the lot or parcel lines are vacated or the lot or parcel is further divided as provided by law. In this case, it is undisputed that the 1972 conveyance did not divide property one as provided by law. As a matter of fact, I believe staff indicated as much in their presentation. Accordingly, in the words of the statute, property number one remains a discrete lot or parcel and is subject to verification. In fact, LUBA confirms that an unlawful conveyance does not divide a lawfully created parcel in the Doty case. In Doty, an applicant sought to site a replacement dwelling on a tax lot that had been unlawfully created by deed in 1992. LUBA held that no replacement dwelling could be sited on the tax lot because the conveyance of the property in 1992 did not lawfully divide the parent parcel. The issue in Doty was not whether or not the parent parcel itself was lawful. The issue was whether or not one of the resulting lots or units of land created by the conveyance was lawful. LUBA said it was not, and as such, the parent parcel remained the only viable legal lot in that case. The same is true in this case. The 1972 deed did not lawfully divide property one, and as set out in the statute, it remains a discrete lot or parcel. As this discrete lot or parcel is a lawfully established unit of land, it is subject to verification under Lane Code Section 13.140, Section 3. And as property one meets the only requirements for verification and has not been divided as provided by law, we respectfully request that the board overturn the hearings official's decision in this case and verify property one as a legal lot. I'm available for any questions.
Thank you.
Thank you.
Do we have any neutral parties? Any persons opposed to the application? Sean Malone.
Good afternoon to the board. Sean Malone, as you read, here on behalf of Landwatch Lane County.
Please state your address.
Sure. P.O. Box 1499, Eugene, Oregon 97440. So everyone, every reviewing entity, person, body that's taken a look at this in the case law under Doty, ORS 92017, and there's lots of case law prior to Doty. It's really just the most recent one that really establishes these issues, but the Oregon Supreme Court has addressed this in a case called Ludwig. There's been a whole series of cases in which these sort of legal lot issues have arisen, and we set that out sort of chronologically and thoroughly before Luba in the Dowdy case, more recently in a case called Leckie v. Lane County. That went to the Court of Appeals. These same principles were reaffirmed there. So this issue sort of has been up to every area of Oregon courts, including Luba, which is not necessarily a court. So everyone's disagreed with the applicant on this, including staff, planning director, hearings official, and the board hired this hearings official as an expert in land use. You're paying him to make these difficult decisions, so it would make sense for you to defer to his decision. And more importantly here is that, again, this is all state law, so nothing of county policy is arising out of this decision. So there's no benefit to essentially anyone, applicant, opponent, et cetera, by holding this hearing. Really, the only people that are getting paid here are the attorneys. I assume the county folks are going to get paid regardless of whether this happens or not. So Landwatch incorporates its testimony before the hearings official, before the planning director, the staff reports, and the hearings official decision. I feel like the staff's review here was thorough and correct. But again, don't listen to me, listen to the hearings official, listen to your planning director, listen to your staff. If these were issues that were on the fence, I think it would be something else, but this is long-established case law, ORS 92017. It's been going on for a long time. We've heard these arguments about as provided by law. This is not the first time these have been before Luba or the Court of Appeals, and it always turns out the same. There's another remedy for folks that find themselves in these positions where they obtain an unlawfully established unit of land, and it's been long part of ORS Chapter 92. And in fact, it's the one after ORS 92017, it's 92018. And they're allowed to sue the person they bought the property from in circuit court and get damages. And I don't see why people don't do that as opposed to go through these processes. It's been used a couple of times by people, but that is one of the remedies that the legislature has provided for individuals who unfortunately purchase unlawfully established units of land. And there's various areas of review or processes of review for people who do purchase land, and the people that they rely on to review those titles and to go through the deeds, those people should have caught these things in all likelihood. So again, the legislature provided an opportunity in the form of a remedy under ORS 92018 to address this very issue. We've talked about these three potential fixes that are up here. None of those are in the hearings official's decision, so they're really unbriefed matters before the board here. It would make sense if the board is considering those to allow the parties to brief those further. So we have some sort of background. We had Mr. Reeder sort of off the cuff kind of talking about why maybe those wouldn't work or why potentially they would work. I have issues with all three of them. Property line adjustment deed, for example, right now, if you're applying for a property line adjustment, you need to do that. So you would need a modification of application in addition to the notion that you probably need lawfully established units of land to carry out a property line adjustment. Warranty deed, rescission deed, this is all sort of trying to almost turn back the clock, which you'd have to ignore the past, you'd have to ignore these unlawfully established units of land. So there's problems with that, but if the board is considering those in any manner, then it would really make sense to have the parties brief those issues. But broadly speaking, we disagree with them. there's a variety of problems with those. We've heard a lot about going into the issue of Dowdy, and it gets complicated. There's a lot of areas of law, there's a lot of case law, but fundamentally it comes down to this. If you have one piece of property and then you decide to carve out a smaller piece of that property and just deed it off to someone or sell it to someone, then what you've essentially done is partition that property. And when you do that, you don't have an old piece of property and a new piece of property. What you have is actually two new pieces of property. So like if you were to go through the lawful process of partitioning one piece of land into two pieces of land, you now have two new pieces of land. It's not an old parent property and a remainder or something along those lines. Those are all terms that LUBA has disagreed with because they don't actually really exist in our state law related to land use. But the simple fact is that because you're creating two new pieces of property, you've essentially divided it, and if you didn't go through the land use process, you did it unlawfully, what results is two unlawful pieces of property. And that is the holding in Dowdy. It's that simple. And so that's why staff, hearings official, planning director are all looking at this and saying, yes, of course, Dowdy applies here. You want to carve something out of one piece of property and have two. Those two pieces of property are going to be unlawfully established units of land. That really breaks it down very simply. This case called Castle has been referred to, but what hasn't been spoken of is how Castle was confined to its own facts and very specifically a forced template dwelling application. That was done, I think, in Dowdy, actually. Again, there's a lot of cases, but what you didn't hear is that Castle has virtually no remaining effect for anything except for out of this narrow circumstances of facts related to forced template dwellings. And that is really it. I'm happy to ask any questions. I would caution the board pursuing one of these potential fixes, because again, they've really never been tested without having some additional briefing on them. So if that were the case, I would ask for some additional, leave the record open potentially. And I'm not really sure if anything has come into the record today. And if so, it would make sense to have an opportunity to respond to that. Again, I'm not actually sure if anything's come in today. So I am happy to answer any questions, but don't listen to me. Listen to your hearings official, listen to your planning director, listen to your staff. They got it right. And again, happy to answer any questions.
Thank you.
Thank you.
Okay, we're to our director's response.
Circling back around. Okay. So just to clarify, the only new items added to the record were received yesterday, one from Mr. Reeder and one from Mr. Malone. Those were both directly addressed to the board in email format by those parties. So you should have already received them. You may have looked at them. You may not have. But thank you, commissioners, very much for your time on this. I just want to reiterate and be 100% clear that neither the director nor the hearings official are interpreting Doty. The county made the same argument that the appellant is making in this application in Doty. In Doty, the county argued that because the C property was the property that was conveyed out of the original A property, it was the only unlawful result. I.e., just like the appellant is arguing here, that B remained lawful, or B and A, or A remained lawful, that the unlawful conveyance had no effect on it. LUBA disagreed with this expressly and found that in the context of land use law, the lawful status of the subject property could only have been preserved if the county had approved the conveyance, dividing the property into 2 units of land. As such, without being rectified, the property is in an unlawful configuration. We want there to be a remedy, but we understand Doughty to not allow for the interpretation presented by the appellant because we've already made that argument at LUBA. and we're bound by Luba's decision. So we made the decision in the way that we did. There was talk about doing an open record, and if there's desire to have an extended open record, we'd be happy to discuss that, but I think we can do that after we close the hearing. Otherwise, that's all I've got right now. Unless Lindsay has some more, and I'm ready for questions.
Vice Chair.
Thank you. I'm going to follow up on the questions that I had earlier for the appellant. So we have the original lot, Lot A. They did a conveyance for Lot B and C, but that didn't make them individual legal lots. It was just a conveyance of interest, ownership, I suppose, is what you'd like to say. And now what they're asking for is for those other two, lots B and C, to be divided out as legal lots. Am I correct?
No, what they're asking for is for us to recognize the original A lot as a lawfully established unit of land. But Doty says that we can't do that because it's been divided since its original lawful creation.
So the original lot is no longer legal because of the attempted conveyance after the fact?
Yeah, I find it confusing because you have to hold two thoughts in your mind at the same time. You have A, that was created lawfully, and then you have, in the case of this application, you essentially have like B, C, and D that exist now. A remains a lawfully established unit of land, but Doty says that even though that A might be a lawfully established unit of land, because it's been divided, whether that was unlawful or not, that division has to be fixed before A can be recognized for land use purposes as a lawfully established unit of land.
Okay. Hence the suggestion for a change in the deed, so that you can make it one lot again.
Yeah, we presented the three options we gave are ways that we have seen or that we think could fix that problem because they provide a way for someone to return A to its configuration that's lawful.
But if they do that, if they attempt to do that, I'm guessing that's fraught with a challenge
Maybe.
from other parties. So
Maybe.
then, if they attempt to do the deed change, even if it's only $200, they could be challenged on that particular deed attempt. And then, I'm guessing at that point, then if they win and that worked, and let's say everything went swimmingly, then their attempt to redivide back to basically the lines of the conveyance, their original request, that then could then also be subject to another challenge.
Yes.
So it's not just as easy as just saying, I'm going to just write $200 check, we're going to do the deed, and then we're going to divide the property again. If it were that simple, they would have done it.
It's hard to say really because we consider through consultation with county council and through our own experience with these matters, we consider the three options to be viable. And they could potentially be appealed, but we've thought about it a lot, and it's our consideration that they're solid. And whether the appeal leads to a different interpretation or not is up in the air. That's one of the problems with legal lots in general. is that they're so litigious. You could come up with 25 reasons to appeal something for every one of these applications. I've been working here for 8 years, and I've done almost 150 appeals related to legal lots alone. So any interpretation that we make here could potentially go to a higher decision body.
That happens every time.
Yeah.
A land use item comes before us. Almost exclusively will they always be appealed. And I understand that, but I want to get this one right. So looking at the original lot, I mean, the rationale of it is no longer a legal lot because they attempted to convey it to different parties after the fact. I'm struggling with that. And that may not be our interpretation. That is clearly this Dowdy case interpretation that went to the state. I'll leave it there. I'm really struggling with that particular logic at the moment.
Commissioner Farr.
Thank you, Chair. Just trying to make sure that what I feel like is clarity in my mind is actually clarity. You know, I'm not interested in overturning the hearings official's decision if it's the correct decision. But I'm also not under the disillusion that the hearings official's decision is always accurate. I mean, if you look at the Ninth Circuit Court of Appeals, 2 judges have different opinions, and a third makes a decision. You know, so even the highest level judges sometimes differ in what their opinion is, and it differs. Sometimes it may be philosophically, sometimes it may be politically, whatever it may be, but differences do occur. Therefore, I'm not interested in overturning just for the sake of overturning or just because the appellant is making a good case. I want to do it because it's the right thing to do, and not just for this particular case, but as Attorney Bidke stated, it could potentially have far-reaching effects. It would clarify and simplify future decision-making. So for me, the simple solution in this matter is simply recognizing property, what we're calling property 1, as a legal lot. And my question on that one, and anyone can answer this question, does that not solve all of the issues of property lines if there is a difference of opinion between the adjacent property owners on the same lot? Doesn't this provide with an elegant solution?
I mean, I don't disagree that is an option. I do think that that's the same, that was our practice before Doty. And people would apply for legal lots where there's multiple owners, and we would say, great, approved. It was a legal lot at this one point in time, and all of these owners signed on. There's multiple tax lots, but it's one legal lot. And then Doty came along and said that, no, you can't do that. It's not in the same legal configuration anymore for land use purposes. So
thanks, Kevin. That gives me a bit of clarity as I move forward on this. And there's been some question as to whether or not Doty actually specifically applies to this. Now, one solution that was offered by one attorney saying, just let them sue each other. Oh, yeah, let's do that. Let's just go sue until you've settled it out. But suing doesn't provide case law, does it? If you win a lawsuit, that doesn't provide a judge in the future saying, well, that person won this lawsuit, so therefore I'm going to base my decision on the lawsuit. That doesn't happen, does it? So that being said, what we have an opportunity to do here as a Board of County Commissioners, and it'll be backed up by whatever the next steps after this is to guide us toward clarity on this particular item regarding the original legal lot and illegally subdivided lots. Subdivision is not the right word, but illegally created lots, tax lots, that it's happened subsequent to whatever the deadline was, whether it was 60 or sometime shortly thereafter. So doesn't this give us an opportunity as a Board of Commissioners to say, let's take a look at it from this window, and if it's overturned, then it's overturned. And I'm not saying that the hearings official is wrong, and I'm not saying that our planning director is wrong by any stretch of the imagination. What I'm saying is we have a chance to maybe clarify it for future generations. And I think I'm beginning to lean toward that from my seat right here. And I've not heard any reasons yet to not lean toward that. I'm not prepared to make any motions to that effect at this point in time. But Attorney Bidke said simply, overturn the hearing's official decision and verify property one as a legal lot. You could provide findings from that if we gave you that instruction. Is that's clear enough for you to give us findings that would satisfy whatever the nuances of findings have to satisfy?
Yes? County Council?
We can try.
So, first of all, I wanted to mention that, just remind the board that there's final rebuttal by the applicant following this conversation.
That's why I'm trying to stay at about 30,000 feet on this. Thank you.
Yeah, so we could do that, and then we would go back and have more. I mean, it's sometimes advantageous for the applicant to have a little bit of this discussion, because then they have something to rebut. So we don't want to have the whole discussion afterwards, because then they don't have an opportunity to rebut it. But at this point, it might make sense to do the final rebuttal, and then if you have any questions after that of staff, you can do that at that point.
Okay, perfect.
Then let me just, with a one final punctuation point, I suggested that going back to property A as being, going back to that decision that that's a legal lot, seems to me to be an elegant solution that would satisfy a lot of the contention that has arisen. That's all, thank you.
Okay, Mr. Reader, you're up. Final.
Thank you, Board Chair Senega and Commissioners. I'll try and be brief, but I do want to be thorough. You guys are putting a lot of mental energy into this, which I appreciate, because it took me a long time to really figure out this issue. And counties, rather than calling it an interpretation of Doty, maybe we can talk about it being a misapplication of Doty, which is what it is. They're using Doty to support a position that overrules ORS 92017. And let me explain that. So I heard Mr. Gilbride say that there was Doty stands for the proposition that when there is a conveyance without a land division, that is a partition, or that's an unlawful parcel. Well, with all due respect, ORS 92 defines parcel, it defines lot, it defines partition, and it defines subdivision. ORS 92010 defines parcel as follows: means a single unit of land that is created by a partition of land. Partition means either an act of partitioning land or an area or tract of land partitioned. Partitioning land means dividing land to create not more than 3 parcels of land within a calendar year, but does not include, and it talks about tax lots and other things. Then when you go to ORS 215, 010, it says, as used in this chapter, talking about EFU property, which this is, the terms defined in ORS 92010 shall have the meanings given therein, except that parcel includes a unit of land created by partitioning land as defined by the statute, in compliance with all applicable planning, zoning, and partitioning ordinances and regulations, or by deed or land sale contract if there were no applicable planning, zoning, or partitioning ordinances or regulations. Nowhere in that definition, either in 92010 or 215010, does partition mean conveying property without going through the land division process. So when LUBA uses the term partition or parcel, or in Doty, what LUBA said was unlawfully created parcel. There's no such thing as an unlawfully created parcel. It's a unit of land that is not a lawfully established unit of land. It's not a parcel. They're talking about it in the metaphysical sense. It's very similar to if you look on the county records and you have a 4-bedroom home, the county recognizes you have 4 bedrooms, but your children, let's say they're twins, they share a bedroom and they put tape down the middle and they say this half is yours and this half is mine, and we've partitioned partitioned it. Well, the county doesn't recognize that tape as a partitioning, okay? It's an inelegant way of talking about something that's very, very difficult to discuss, and even land use attorneys get it wrong sometimes. I actually agree with Mr. Malone, and I've said this before. Sometimes we use the wrong terminology, like parent parcel or remainder. In Doty, Luba said that the remainder parcel was not a lawfully established unit of land, B. And C itself was not, it says it was an unlawfully created parcel. Nowhere in Doty does Luba say all of A, the entire parcel, is somehow not a legal lot. That language is simply not there, with all due respect to Mr. Gilbride. Here's the holding of Doty. Differently here, the issue is the current land use status of tax lot 1400, so very similar to our tax lot 304 owned by Kelly Chambers. Contrary to the hearings official's conclusion, the 1992 conveyance did not create one compliant developable remainder parcel. So Mr. Gilbride, if you could go back to the Doty slide that you had there. B. That remainder up north, that's not a lawful parcel by itself. And one unlawful, undevelopable parcel designated tax lot 1401. Such a reading would in fact allow the creation of a developable parcel in violation of applicable land use laws, with the reduced size parcel designating the parent or remainder. There's no parent, there's no remainder. There is just a lawfully established unit of land where there was a conveyance in 1972 without land division approval by the county. That is the holding in this case, and you have to look at the statute. You cannot extrapolate from Doty something different. We've provided other case law and briefing that will provide the findings for your motion C, and we're happy to draft those findings on behalf of the county. But I want to make something clear as well. Mr. Mitke also provided briefing in this case. So you have his 2 or 3 page letter supporting our position. So it's not just staff, it's not just the hearings official, there's other attorneys. I don't know of any other attorney that practices land use that believes that the unlawful conveyance breaks apart a lawfully established unit of land, because such would violate the principles of ORS 174.010, which is to say that when construing a statute, a court may not omit what is inserted or insert what is omitted. Staff and the hearings officials' extrapolation of Doty would erase that as provided by law in ORS 92.017. And I don't want to bore you too much, but there's additional contextual analysis in the ORS that support our position, and that is ORS 92.176, which talks about validation of unit of land, and then more importantly, ORS 92.177. In ORS 92.177, the legislature specifically said that when you're in this situation, if you don't have agreement among the parties and there's someone with an unlawfully conveyed piece of property, that if it would have been lawful in 1972, in this case, you don't need the permission of the other owners of the lawfully established unit of land. You can go to the county by yourself and validate that unlawful conveyance. And if 171 wasn't there, you could say, well, 176 allows this other avenue, but the legislature recognized that sometimes you don't have cooperative neighbors. So here we have cooperative neighbors, and that's a good thing, so we can take advantage of current law. Other people are not as fortunate, and they're in that category where they would have met the standards at the time, but they need the cooperation of their neighbors. ORS 92.177 provides an out for that person who has that unlawfully conveyed piece of property. They don't need the permission of the other property owners, and that was to get around the problem in the Killian decision, where the Court of Appeals said, look, if you have a piece of property that's not lawfully divided, you don't get to further divide that property without the consent of the other property owners. And so, hence we have ORS 92177. Sometimes hearings officials get it wrong. Sometimes private land use attorneys get it wrong. That's just the nature of law. So to say that, to say, well, we don't want to overturn the hearings official because the hearings official is an expert, well, the hearings officials were experts in the Jenkinson case. They were expert in the Sharon Carroll Simpson case that went to the Court of Appeals and overturned Lane County hearings officials' decisions. Sometimes they get it wrong, right, sometimes they get it wrong. In this particular case, with all due respect, the hearings official got it wrong. Thank you for your time, and I'm happy to answer any questions that you might have.
Okay, board, we have 15 minutes. We do have time certain reserved on May 19th at 1:30. If we get all our information in, we can finish deliberating then if we don't think we can get this wrapped up in 15 minutes. Okay, to the board. Commissioner Trieger.
For staff, can you remind me all the steps prior to something reaching the hearings official?
All the steps prior to,
To this going before the hearings official?
you mean procedural steps, like?
Correct. Like,
So.
The planning director reviews it, what the application went through, how many hands?
Yeah, we go application submittal, it goes through administrative staff, then it's assigned to, well, it's given to the planning director who assigns the application to a planner. In this case, it's one of our legal lot professionals. And they review the application for completeness. They reach out to the applicant if it's, or they write a letter that says it's complete to the applicant if it's complete, incomplete if it's not. Applicant provides more information if necessary. We send a referral notice where neighbors are notified of the application having been submitted. Then we review the application for its compliance with the necessary criteria. Then the application is given to the planning director for review. Then if there's edits needed, that goes through that process. Then we mail the application to neighbors, or the decision to neighbors, notifying them of the decision. They have opportunity to appeal, then it goes to the hearings official if it's appealed.
These don't go to our planning commission?
Nope.
Okay. Thank you.
I haven't said that in a while. I haven't worked at the front desk in a long time.
Thank you.
Sounded well rehearsed. Commissioner Lovell.
Thank you, Chair. Was there something that generated this whole mess? I mean, was parcel number one going to try to build something and ran into a snag, or was the pink parcel people trying to do something and ran into a snag? Or are we just trying to get ownership and divisions in order?
I think the applicant would have to answer that. I don't know for sure. Maybe Lindsay does.
Well, the application before us is not only a legal lot verification, it's also a combined property line adjustment. So I think that, I don't know what development they would necessarily want to do on the subject property, but they, in this specific instance, they want to adjust the property lines after we determine whether or not if it was a lawfully established unit of land.
So if property number one, yellow property for the slide's sake, wants to come and build something on there, and they come to you and want to apply for an application, are you going to tell them that this is an illegal lot based on DOTI, that they don't have standards or rights of their property to build something? And same is true for the pink lot owners? I mean, are we at a developmental landlock on both sides because of the interpretation the staff has taken on DOTI making yellow lot an illegal lot now?
Well, for clarity purpose, I think they're fully developed already with dwellings.
Doesn't matter. It's not what I'm asking. People are always going to build something.
What we would tell them is that the lawful status, like if they came into the front desk and asked us, we'd say the lawful status isn't clear and that they need to apply for a legal lot verification, and that the legal lot verification would be the determination as to whether the property itself already has development rights, because we're determining whether it was established lawfully or not.
I'll also add to that, some uses require us to make the formal determination if a property is lawfully established, and other uses do not require that determination.
Right, that would be like a farm building or something like that, or an ag building, right, I get that. But what I'm saying is that the article before the board is we, in my mind, is I have a choice here. I have a choice to agree with the hearings official and saying, well, sorry, 2 lots are going to be locked up, can't get a permit to do anything unless you want to do an ag building. Or I say, I agree with the way it's been presented to us by the appellant, that yellow lot is still a legal lot. They can still get building rights, and the pink lot guys are going to have to figure it out in another venue. That's kind of where I'm at as far as choosing what to do here. Is that somewhere in the ballpark? I'm trying to figure out if both those lots are locked up for non-development from here on out, and they're going to continue having this hassle, or if at least one of them is going to be able to come to the planning department of our county and say, I want to build something, and they're not going to have to go through a bunch of legal issues.
I think maybe this alternative slide might help. So what they're applying to do is they applied for legal lot verification of 3 properties, and then they want to go through property line adjustment. And the ultimate property line adjustment is the picture on the right. And what that does is move the property lines into what is similar to the configuration that exists now. So the yellow A property that we've been talking about this whole time, you can see that it's the pink there, and it would result, after the property line adjustment, it would result in the same property just lawfully. So what they're recognizing is that they're not I keep flipping back and forth, but they're not currently in a lawful configuration, and they want to put them in a lawful configuration. I don't know if that's getting to what you're looking for.
No, it's not, because now my question is, of those 3 properties, if either one of those 3 properties come and wants to do a building permit, which one's going to have the hardest time?
I guess I'm lost in translation. Which 3 properties are you talking about? Are you talking about the 3 ultimate properties, or are you talking about the 2 yellow properties and the pink property?
Well, if we're saying that the pink property, and this is where it gets circular, right, where everybody starts getting confused. If we're saying this pink property was not a lawfully created lot, but yet we're saying the yellow property is still remaining a legal lot, my question still is, of the yellow remaining lots, if those people went and come into the building department wanting a permit, because if I'm interpreting what I think the position would be, that that's still a legal remaining lot, they should have every right to pull a building permit to build what they want. Pink property is going to have an issue.
Well, you're describing Doty. Because in Doty...
I'm getting an agreement from you and a head nod from somebody else behind you who's on the other side of the fence. So what is it?
Yeah,
So I'd like to have Mr. Reader answer that as well, too, please.
The way you're describing it is the same situation as Doty, that there's this greater lawfully established unit of land that was divided, and somebody comes in and wants to develop on, in this case, it would be the yellow property, and in Doty, it was property B, which is,
right.
I'm getting lost in my own slides. It was property B. And the hearings official was agreed and said, sure, yes, you can develop on yellow. That's the original lawfully established unit of land. And the county agreed with that. And in Luba said, no, you can't do that. And that yellow property is part of this broader lawful unit of land, and that has been extinguished through your unlawful division for now until you fix it. And then you can apply for your dwelling or replacement dwelling. And so in answer to your question, if somebody came in to develop on yellow, either of them, we'd have to say no, because they're not lawfully established units of land in the same way that pink's not a lawfully established unit of land, because the lawful one is the original larger yellow, including pink.
See, you just answered my question. So then that way, now we've said that all 3 of the properties can't pull a permit. That was my question, according to what you just explained.
Well,
and where I'm saying, according to what it appears, yellow should still, as a legal lot still be able to pull a permit.
But that's the same argument that was made in Doty, and Luba said no.
But LUBA is not a legal body. LUBA is an opinion body. This is not a court-tested body. That's what I'm after. I'm after, are we restricting more building in the country than we need be? Yes, go ahead.
So we currently do not have a final noticed legal lot verification that was approved on the smaller configurations or the larger configuration.
All right, for the sake of time, my opinion would be that we as the board decide to test this, deny the hearings official's opinion, and put this before a legal body that can straighten this out. I think it should be challenged. I think the board has an obligation to challenge it, because if we don't, that leaves a conveyance, which is not a legal divided lot, from a legal divided lot. It locks up all of it. And I think that's wrong.
Was that a motion?
I would put that as a motion, yes, if I could repeat it.
Would you like to restate it?
I would go for motion number 3, to move not to adopt the attached order and direct staff to return with the revised order consistent of establishing that LUBA is not a legal opinion body in this case, and that the conveyance does not nullify the existence of an original legal lot.
Counsel.
Yeah, so I want to help you with your motion.
Help me with my motion.
Because I think that you can say what you want to say without saying that part about LUBA.
Okay, I didn't know how specific we needed
LUBA's
to be.
controlling, they're not a court, they're an executive agency, but you're still bound by LUBA's decisions. So everything that you said other than we don't care about LUBA because they're not a court, I would, try to restate it without that part.
I'll retract that part and just not restate it. How's that sound? So I would like to direct staff to come back to reverse this hearings official's order, and now I'm getting confused, and to find findings that the owner of lot 1, or lots 1, the yellow lots. Yeah, I could read that, but how specific you want me to be on this? Because I'll agree with motion number 3, but my hearing in this hearing was that we were supposed to be specific about what findings we wanted to come back with. Is that not what I heard,
What you
right?
can do, the applicant has kindly offered to draft the findings.
There you go. Let's do that.
So without having to put that burden onto staff, you can basically say something broadly about that they'll come back with arguments consistent with what they've made so far.
Okay.
And that they will draft the findings.
I'd like to move not to adopt the attached order and direct staff to return with a revised order reversing the hearings official denial, and allow the applicant staff to draw up the findings and conditionally approve the application with findings of fact from the applicant's attorneys that include the board's interpretation of Lane Code Chapter 13, associated case law. Excuse me for my voice.
I'll second and speak to the motion.
Okay, we have a motion made by Commissioner Lovell, seconded by Commissioner Farr. Discussion.
And to speak to the motion, Chair, I could have said it much more elegantly, I think. And elegant is, Merriam-Webster says, smart but simple and therefore attractive. Smart, just overturn the hearings official and verify property 1 as a legal lot, then establish the findings through the, I think that's what you said, Commissioner Lovell, but
Yes, thank
so that, and that's what I second, is that the applicant would help with the findings that are consistent with us wanting to overturn the hearings official's decision and verify property 1, the yellow, the overall yellow, as a legal lot. So, Councilor Davies, does that? Okay, thanks.
Commissioner Buck, Vice Chair Buck.
Thank you. I'm going to support this. It's actually quite rare that I do that and overturn or talk about overturning a hearings officer or staff. I know that you are absolutely trying to interpret the Doty decision, and I'm not placing it on you. The main reason I'm supporting this is because I buy Mr. Reeder's argument that the main lot is still a legal lot regardless of the subsequent conveyance in 72. And that's the main reason. The logic of that it's no longer a legal lot simply because of that conveyance back in the day doesn't make sense to me. And I can't support that at this time. I also struggle with the argument that, well, if somebody buys this lot, they should just go back to the previous owner and sue them because it's not a legal lot. In this case, this lot has been in the family for generations. It sounds like 80 years or more. There's nobody you're going to go back and sue at this point. Like, they're probably not alive. So other remedies are just not available. It is very possible I'm completely wrong, and I'm not a land use attorney, and this will likely be appealed. But I wanted to put on the record the reason why I'm supporting this.
Thank you, Vice Chair. Any further discussion?
Yeah.
Commissioner Lovell.
Yeah, I just want to say too, Kevin, you guys have done a heck of a job, dug deep, no blame intended here. I just want to make sure that the far-reaching effect is other people in these cases aren't nullifying everyone around its right for building or permit approval for the county. I think that would just cloud things up, so that's my intention here. Thank you.
Okay, that's all the discussion. I'll call for the vote. All those in favor signify with an aye.
Aye.
All those opposed?
Nay?
Motion carries 4-1 with Commissioner Trieger and nay. Thank you.
Excuse
the
me,
Eichner.
Chair.
Hold on.
One more question for
Yes.
you on that, or clarification, is we did not mention a date or time. That's why I was conferring with council. If we should be having a date or time certain to return on, or if the hearing's closed and it's just for deliberations and coming back for an order. I'm not.
Yeah, so generally, we just had a public hearing. So what you'll want to do is you want to at least close the hearing and close the record if you're wanting to close the record. Having findings from the applicant we can have that and still close the record today. But I think what Lindsay's concern is that we should have a date that we're going to come back for deliberations. And it's too soon to come back on May
19.
May
Yeah.
19th, our packet would be due downtown tomorrow.
Yeah, that was for
I'm
deliberations.
assuming
Yeah,
that
we need to work with the
can't get findings prepared and ready to go by Friday.
Somebody in the ether is listening to us right now. I'm surprised she hasn't spoke up. But I did close that's what I said, Chair, or this concludes the presentation of the de novo hearing. That was what's in the
It's in the script.
script.
I mean, I like to be more like specific, like I am now closing the hearing and I'm closing the record, just so there's no argument from someone who might claim that that's not exactly what happened.
This concludes the presentation part of the de novo hearing. The de novo hearing is now closed. The Board of County Commissioners will now begin deliberation towards a decision.
And the record is closed.
The record is closed. Okay. Perfect. Thanks for keeping us straight.
But the date.
If you're looking at dates in June, we could do any of the meeting dates of June 2nd, June 9th, or June 23rd.
Looking at Mr. Miller, reader.
Wait,
We're down on the
we're
16th.
it's down.
Oh, the 16th.
2
9
9s.
or 23rd.
June 9th?
June 9.
June 9th, do we want to do a 1:30 time certain, Ms. Gibb?
Just one moment. Yes, that is a possibility.
June 9th at 1:30.
Yes, I think that'd be work for staff.
For staff to return June 9th, 1:30 time certain? Okay. All right. Well, I appreciate everybody helping us get through that. Lindsay, thanks for coming to the board. Mr. Gilbride, great presentation. I appreciate it.
I'll see you in a minute.
I think it's 10 minutes.
Yeah, it's 10 minutes. Okay. Next up, we have the first reading and setting, second reading and public hearing on ordinance number PA 1394. We have Ms. Norrie here.
Good afternoon, Commissioners. I am Norrie Spradling, Land Management. Staff planner assigned to the matter before you regarding a conformity determination for the subject property that is owned by the Wildish Land Company, and which contains the Thurston Pit, a gravel quarry located just east of Springfield and north of Thurston Road on the south bank of the McKenzie River. Most of the area is approved for the mining operation is designated natural resource mineral in the Rural Comprehensive Plan and zone sand and gravel.
Okay, here we go. First reading and setting the second reading in public. You're ready to go, Norrie. I like it. First reading and setting the second reading in public hearing ordinance number PA 1394 in the matter of amending the Rural Comprehensive Plan to amend the Rural Comprehensive Plan diagram to natural resources, mineral, and rezoning to sand and gravel and rock products. SG 47.94 acres of the subject property in accordance with Lane Code 16252, Lane Code 16400, and Lane Code 12050, Department File 509 PA 2505602, applicant Wildish Land Co. Now, here we go.
Thank you.
Thank you.
So most of the mining operation is designated natural resource mineral in the Rural Comprehensive Plan in zone sand, gravel, and rock products, with the exception of a small portion in the northwestern corner that's designated as agricultural lands and it's zoned exclusive farm use. So the documents that I left over there on my chair are here, the application with the full record of the materials in the matter. Wildish has requested a conformity determination proposing that the portion of the subject property that's designated agricultural lands and zoned exclusive farm use zone was done in error, and that the entirety of the area should have been designated natural resource mineral and zoned sand and gravel and rock products. As a little background, conformity determinations are a process that's allowed in the Rural Comprehensive Plan to change the designation and zoning of lands where the applicant believes there was an error in an identified plan or zoning designation in the Rural Comprehensive Plan's official plan and zoning plots. That results from those plots not recognizing a lawful existing use in terms of zoning, or from inconsistencies between the official plan and zoning plots. In this case, they believe it's the latter. The applicant believes there was an error when the Metropolitan Area Plan, or the Metro Plan, was initially adopted in the area around the city of Springfield, and that the error carried over into subsequent mapping revisions of the area. The basis of the argument is that the Metro Plan policies indicate that there was an intent by the Metro Plan to designate and zone the areas of all existing mining operations at the time in agreement with the type of mining that was occurring. However, the actual mapping of the Metro Plan's designation and zoning, which is referred to as the plan diagram, was done at such a large scale that even the Metro Plan itself acknowledges that the plan diagram should be used for reference only and that the written text should be relied upon for the planning specific parcels or individual tax lots. A summary of the applicant's evidence, including the history of the property and a more detailed explanation of the Metro Plan policies, is in the record before you, along with the discussions of the Lane County Planning Commission, discussions at the Planning Commission, both in favor of, for, and against the proposal. At this time, the Lane County Planning Commission has recommended approval, and staff agrees with this recommendation. This is the first reading of the matter, and a second reading has been scheduled for 2 weeks from now, May 19th, for a de novo hearing. Wait, is that right? Quasi judicial? No.
De novo.
It is a de novo hearing. In closing, I'd like to thank the board for their attention, and staff's available for any questions.
Okay, as this is simply a first reading, the board is reminded that any substantive questions for staff or discussion on this matter should be reserved until the second reading and public hearing. This is so any members of the public with an interest in this matter will have the benefit of hearing those discussions. That said, are there any logistical questions that the board has at this time? Commissioner Farr.
Just logistically, in that it is de novo, then we should avoid discussing this with anyone between now and the second reading?
Yes.
Anyone? my children, my grandchildren, no, thank you.
If I could just add, it's quasi-judicial, so yes.
Yes.
But if I could also put on the record, because I just noticed something that got skipped, now we can take care of it. Does any commissioner wish that the ordinance be read in full? Seeing none, for the record, thanks.
Got it. Yes. Okay. No further questions? Logistical only questions? Please.
I'll move to approve the first reading of ordinance number PA 1394 and to set the second reading and public hearing for May 19th, 2026 at 10 a.m. in Harris Hall of the Public Service Building.
Second.
Okay, we have a motion made by Vice Chair and seconded by Commissioner Lovell. Any discussion? Seeing none, I'll call for the vote. All those in favor signify with an aye.
Aye.
Motion carries 5-0. Thank you. Okay. How's everybody holding up? Do we want to take 5, give Kevin Gilbride a break, or do we want to jump right into learn objective?
I think 5 would be cool.
Yeah.
I think so too. Come back at 3:45. Next on our agenda is proposed ordinance 2507. Is there a request from any commissioner to read the ordinance in full? If not, I'll read it by title only. Eighth reading for ordinance number 2507 in the matter of amending Lane Code Chapter 16 to adopt clear and objective standards for housing in residential areas in sections 16.090, definitions 26.237, significant natural shorelands combining zones 16238, prime wildlife shorelands combining zone 16239, natural resource conservation combining zone 16240, residential development shorelands combining zone 16240, residential development shorelands combining zone 16241, shorelands mixed development combining zone 16242, dredge material mitigation site combining zone 16243, beaches and dunes combining zone 16253, stream riparian regulations, rural comprehensive metro plan, and 16254, greenway development permit, rural comprehensive plan, as required by Oregon Revised Statute 197A400, updating references in other sections of Lane Code and adopting a savings and severability clause and declaring an emergency file number 509 PA 2505301. We really need Commissioner Farr here. Do we have any conflicts of interest? Commissioner Lovall.
I do not.
Commissioner Farr, do we have any conflicts of interest?
I have none.
Commissioner Trigger.
None.
Vice Chair.
None.
And I also have none. Okay. So, does any member of the public wish to, now ask for challenges to any commissioner's ability to participate in deliberations on the ordinance. If anyone wishes to challenge a commissioner for a conflict of interest, the challenger should explain the basis of the challenges. Commissioner challenged shall have an opportunity to respond and state whether they are able to proceed without any actual conflict of interest. Does any member of the public wish to challenge any commissioner's ability to participate in this matter? Seeing none, I'll hand the presentation over to staff.
Thank you, Chair Senega, and good afternoon, Commissioners. For the record, I'm Rachel Sursliv, Senior Planner. I also have here with me Kevin Gilbride, Senior Planner, and we have our trustee legal counsel, Ann Davies. So staff was last before you with Ordinance 2507 on April 14th, 2026 for a 7th reading, and we are here before you today for an 8th reading of the ordinance. At the 7th reading, the board moved to set an 8th reading for today and did not direct staff to make any changes to the ordinance. Therefore, we're back before you today with the ordinance as written, and staff is recommending that the board adopt the ordinance today. That concludes my staff report. Happy to answer any questions. Thank you.
Okay. Do we have any questions for staff? Commissioner Farr.
Is this the time for questions and/or comments? Just, okay.
Yeah. Yeah.
So I'll say this right up front. I'm prepared to move the ordinance today, and I'll prepare to say why, but not as at length as you wish me to, or as briefly as you wish me to. So briefly, we extended the readings of this ordinance to an 8th reading, and during that period of time, a lot of very positive things happened, in my estimation. A lot of things that really helped clarify where the ordinance was and what is going to happen subsequent to the passage of this ordinance, should it pass today or whenever. And the one thing that did happen is that we engaged a third party, presumably neutral third party, which was Lane Council of Governments, to moderate and mediate a series of meetings between I've got the list of the participants here. And it had a chance for people to really believe that their questions were thoroughly asked and thoroughly answered, thoroughly vetted. And significantly in my mind, many of the questions that were raised are more adequately addressed in code review as opposed to ordinance form. And so subsequently I talked to members of LMD and talked about the next step in code review. And I believe, Mr. Mokrajewski, we actually have some, funds budgeted for code review in the next fiscal year. So that's a step in that right direction. So some of the questions that were raised regarding riparian areas, regarding, I don't have the specific ordinance number, it's, maybe you can help me with 16 point,
25-07.
253, right. Some of the questions that I had and that I persisted in asking are better addressed in code as opposed to in ordinance. So I believe that we're satisfied at this point in time. And it's been, the ordinance hasn't changed from the last time that you've read it. And my questions have been satisfied. All parties have had a chance to participate in the process. And I believe that at this point in time, questions have been answered, other than the fact that we do have a code review that's budgeted for and will occur over the course of the next year. So with that, Chair, I'm one commissioner only, but I'm prepared to move the ordinance.
Any other questions? Commissioner Lovell.
Thank you, Chair. I'd just like to recognize my colleague, Commissioner Farr. I want to thank you for taking tip the spear on this. I think you vetted it very thoroughly. You brought the right parties together, you brought the right mediator, and you brought the right course of action, because you knew you wanted to get it right, and we were here to support you, but it was kind of your baby that you took, so I would just appreciate you and thank you publicly for doing that, and I think we're on the right track to get the right result to make sure that we're not impeding any building in the coastal zone or in the rural zone, so I want to thank you very much for that.
A tiny little response, I hardly do or did anything. It's the folks sitting down there that do it.
Well, and then the thank you goes to you as well, too. Thank you for your perseverance and patience with us, learning your craft and helping us do it better on your behalf. So thank you.
Okay, Commissioner Buck, Vice Chair Buck.
Are we ready for a motion? Okay. I'll move to approve the 8th reading and adopt ordinance 25-07 as presented. I didn't steal that from you, did I?
No, you didn't. I wasn't even going to second it, but I will. I'll second it.
Okay, we have a motion made by Vice Chair to move to approve the 8th reading and adopt ordinance number 2507 as presented, seconded by Commissioner Farr. Any discussion? Okay, have you, in any of this discussion, have you gone through what section of codes you're looking through, or you just?
I have, and I can't cite precisely what they are, so I won't try to do it out loud. And I trust that staff is going to work together to identify which codes most pertinently are hierarchically, which ones will come first. So, yeah.
Okay. Roll call vote.
Okay, and we go by least seniority to the chair at the end. So Commissioner Lovell.
Aye.
Commissioner Trieger.
Aye.
Commissioner Buck.
Aye.
Commissioner Farr.
Aye.
And Commissioner Senega.
Aye. Okay, motion carries 5-0.
Yeah.
Getting applause. Okay, thank you. We appreciate it. On next to Commissioner Business. Do we have any announcements? Commissioner Trigger. When you're ready.
Mistimed lozenge.
Sorry.
Thank you, Chair. I just wanted to acknowledge, I hope I'm not stealing Commissioner Buck's thunder, if she was going to mention, she and I both attended an event over the weekend together, the TIP program, the Trauma Intervention Program, which some folks might remember hearing about because it just started about 3 years ago and initiated through some community requests for the county to partner and provide some support and funding. But this is a entirely volunteer-driven program where first responders, when there's a traumatic event in the community, can call in a TIP volunteer to come and be with the people who witnessed or are otherwise impacted but aren't the direct victims, if you will, of an incident. It was a really moving event. They call it Hearts for Heroes, where they recognize the first responder and the TIP volunteer that they called in to help at the scene. And these are often really, scenes of violence, car accidents, house fires, people coming home to find a loved one has committed suicide, really urgent traumatic events that require a quick trip to the ER with a young child. It was one of the cases. Really moving to hear these stories and acknowledge. And so it was going to be a great event to go to no matter what. But of the a dozen or so recipients were 4 of our own Lane County Sheriff's Office deputies. And so I just wanted to especially acknowledge and appreciate Deputies Hearn, Lane, Grotefend, and Brooks. It was really an honor to be there at that event and see all of the recipients, but particularly our own deputies from our sheriff's office for their work with that program. Thank you, Chair.
Absolutely. Any other announcements? Well, I'll just announce that Commissioner Buck must have had a busy weekend because we were at the Lavelle Winery for the IAFF, International Association of Firefighters 851, to support the Wayne Fire Authority levy that they're working on. That was a great event. Had the yard dogs out there. The band, they were really good. It was a good time. They firefighters put on a good show. If you guys ever they're ever putting a levy in your area. Yeah, and I shout out to Lavelle Winery. That was a beautiful venue. They did a great job. Any commissioner comments and remonstrance? Committee reports. Yes, Commissioner.
Thank you. You know, on the agenda today, on the consent calendar, we approved 2 new members of the Mental Health Advisory Committee. And having worked on that committee for a long time, it's not always been easy identifying who are the perfect people to serve on that very important committee. And I think whoever went through the process this time did a really good job of selecting the new members of the Mental Health Advisory Committee. Same thing happens on the Poverty and Homelessness Board. It's a broad spread board with a matrix of positions that need to be filled. And you want everybody to be a participant and everybody to really engage in and contribute to the process. And it's not easy to find. You know, we have our committee work, but finding the members of the committee is quite often the most difficult part of it. And I really, again, I'd like to commend whoever was on MHAC and the 2 replacement members who were placed on today's consent calendar. Bravo, well done. Poverty and Homelessness Board met on the 16th, and we have had a pretty broad spectrum of discussion on that board. That is one of that's the only commission other than, in fact, Mr. Mokrowski can correct me if I'm wrong, but the Poverty and Homelessness Board is broadcast live and rebroadcast on a number of occasions. And the reason that was done in the first place was because it is a multi-jurisdictional committee that if you look around the different regions, the different counties, they look at our Poverty and Homelessness Board and say things like, I wish we had something like that. It really is a powerful body of members. Sean Murphy is the chair, currently the chair, and does a superb job of handling those meetings and guiding them in the right direction. So that's my committee report, Chair.
Any other committee reports? Do we have any future board assignments? Okay, any other business? Other than a budget committee till 8:30 tonight? All right, at the sound of my gavel, we will be adjourned. Next scheduled Board of County Commissioners meetings is Tuesday, May 12th, 2026. Thank you.